All right, let's get started. It's on the hour. People are still filing in, but we're going to get started anyway. I'm Jeff Youngren. I'm on the clinical faculty of the University of New Mexico. Been around a while. It's a privilege and a pleasure to be able to host this talk. I want a couple of rules and reminders, one of which is those of you who are getting medical CEs, there will be a link posted. It just was posted for you to click on. To those who are psychologists and other mental health professionals that are getting CEs through APA, that link will be posted to the last 5 minutes of the talk. To get that credit, you need to stay for the whole talk, and then you get that link. Remember, though, that we don't keep a record of that, so you need to click on that, complete the link, and then save your own CE certificate that will be emailed to you from us. No reason to write us because we don't have that document. You need to do it yourself when that link comes up. Also want to remind you that next week, my friend Lenore Walker is going to be the speaker. Many of you know Lenore's work for 35, 40 years as a forensic psychologist, a lot of work in the battered wife syndrome and in forensic psychology as well. Her talk is going to be domestic violence assessment and intervention in the age of COVID. So a very pertinent, timely talk that we will have from her. So let's go ahead and let me introduce Anthony Perillo, who is actually on our faculty. It's an honor to have him join the New Mexico team, the University of New Mexico. Anthony is a licensed psychologist and is the training director of the Forensic Psychology postdoctoral program here at the University of New Mexico School of Medicine. Anthony received his Ph.D. in clinical psychology from the City University of New York's Graduate Center at John Jay in 2014. He has conducted forensic evaluations at in his private practice in local, county, federal levels for the past 6 years, and has supervised clinical trainees in clinical, forensic, and police evaluations. Dr. Perillo has received several honors from the American Psychology Law Society, APLS, including a first-place dissertation award for his research on risk assessment of sexually abusive clergy, and the 2021 Early Career Teaching and Mentoring Award for his work with forensic trainees. Dr. Perillo's ongoing research focuses on factors that influence clinical judgment in forensic evaluations. He is co-principal investigator on a project funded by the NSF. He recently completed a project with his wife, Dr. Jen Perillo, examining cognitive and legal factors that lead to biased forensic evaluations. Dr. Perillo also supports practices to make forensic research more transparent, accessible, and trustworthy, and his paper on open science practice with Melanie Festinger, Brad McAuliffe, and Jen Perillo will be in the upcoming Oxford Handbook of Psychology and Law. So it's my privilege and honor to introduce Anthony, and I will click back in the last 5 minutes of the talk, reappear, and field the questions at that point. Anthony, the show is yours.
Thank you so much, Jeff. I really appreciate that intro. I'm thrilled to be joining and talking a bit about biased clinical judgment in forensic evaluations today. A couple of things to just go over quickly here. I want to thank Dan Murray and Tess Neal over the years in doing different talks. They've shared different examples and slides for me. It's inevitable that I probably stole something from them in an image here that's here, so I want to make sure that they get their proper credit. And then my collaborator, Dr. Jen Perillo, has helped in a number of different ways, both professionally and personally on these projects and in general. So I want to thank her as well. So many of the people that are here on this talk right now are in what we might consider a helping field. But when we specifically are asked to do forensic evaluations, the help that we provide is a little bit disconnected from the help that we've long been trained to do in psychology or psychiatry or social work. In this context, we're being asked to help in terms of providing information that people that need that information to make important legal decisions about facts in a case. And so because of that, we're generally recommended and have guidelines to strive to be unbiased and impartial. We're not supposed to be advocating for a side. We're supposed to be delivering information. Now, the word here, strive to be unbiased and impartial, is absolutely key, because bias is everywhere and impacts our judgment in professional and in personal lives all the time. Now, one thing I want to clarify, generally, when we talk about bias in forensic evaluations, there are multiple types of bias that we should strive to overcome. But usually in the mental health fields, when we talk about bias, we tend to talk about group biases, biases that the evaluator brings in towards individuals because of a group that they belong to. These are our stereotypes and our prejudice. And this is less of the bias that I'm focusing on today. What we're talking about in terms of bias in forensic evaluations is more a process bias, which is driven by the process of conducting an evaluation. So the idea here is, rather than one's own personal biases that they bring into the table, it's an idea of the process of doing an evaluation and how we conduct that, skewing our evaluations in unfortunate and inaccurate ways. Now, this probably does interact with group bias as well, harming certain individuals more than others. My understanding is there has been very little to no research in that area. We've looked at these process biases broadly, but have done less so in looking at how these processes can particularly impact bias toward people of different types of groups. Now, getting to the short of it, are we unbiased in our clinical evaluations? Well, if we were, then I would have very little to talk about right now. We are not unbiased in our evaluations, though many of us like to think we are, or at the very least, we tend to underestimate the amount of bias that we bring to the table and the amount of bias that ends up leaking into our forensic evaluations. Now, can we become unbiased? I mean, I'm talking here about different solutions and ways to address forensic bias, but it is highly, highly unlikely that we will get to a point that we demonstrate a lack of bias in forensic evaluations, even though we're probably going to think we get to that point at some point. But what should we actually be looking for in terms of setting a more realistic target? Well, for the past decade, we've been talking about forensic bias in different types of forensic evaluations. It's time for us to move on beyond understanding and acknowledging its existence into actually understanding its causes so that we can address it. We can't say that we're biased and have it fixed, just like the same way you can't say the sink is broken and then it magically fixes itself. In order to fix that sink, what do you have to do? Well, you need to go beyond saying it's not working to clarifying how it's broken. And then you need to go back and look at what is causing that issue and then address that root cause. And it's the same thing with forensic evaluations. It's one thing to talk about bias, but what we need to be doing is acknowledging the specific types of biases that lead to biased judgment in forensic evaluations. And once we acknowledge not just that bias exists, but what those are, we can start to understand more why that is happening and looking for root causes that lead us to be biased in forensic evaluations. And it's only by diving deep into understanding the causes that then we can actually address the root issue here. So the goal of all of this is not to just magically acknowledge bias and then have it disappear. We need to understand it better so we know what we need to address so that we can actually address the root cause that's contributing to biased clinical judgment. Now, I'm going to briefly go over a little bit of historical information about how we got to this point of acknowledging forensic bias. But we've been discussing forensic bias for cases that came out over 50 years ago at this point. And there were published articles in the early 80s about lawsuits from the Buffalo Creek disaster, which was a collapse of coal slurry dams in West Virginia. 42 miners were suing for psychological damages. And there were experts that were brought in for these lawsuits to talk about this long-term psychological damage that these miners had experienced from this disaster. And they all differed to the degree to which they determined that the plaintiffs had experienced psychological damage. But what we saw was that those that had been hired by the defense tended to find more psychological damage among the plaintiffs, and those that had been hired by the other side had found less issue of psychological damage. So we saw some significant disagreement as a function of the side that people had been hired by. But regardless of the side that you're hired by, we've seen significant disagreement in a number of different other areas. In the early 2000s, Hawaii had a system where 3 independent evaluators would conduct a series of forensic evaluations. So these were evaluators that were not hired by the defense or the prosecution, but they were all court-appointed independent providers. And there was still some fairly significant disagreement on forensic evaluations and people's clinical judgment. So this really highlighted the idea that even if you were coming to this, interviewing the same person, coming from the same angle, hired by the same source, we could still see disagreement among evaluators. We've seen a number of different studies too that even when forensic evaluators seem to agree on the surface, if you actually dive into their core justifications for their opinions, sometimes there is a great level of disagreement. We've seen it in civil commitment for people that have been convicted of sex offenses, where people seem to agree on the surface, yes, this person is a candidate for sexually violent predator commitment because they have a mental abnormality. And then you ask the evaluators what mental abnormality they have, and they come up with different types of diagnoses. So the agreement there seems a little bit more superficial than actually core objective evaluation. But of course, we can disagree with it not necessarily indicating bias, and we can have error without it necessarily indicating bias. The issue here is, are there factors within our evaluations that lead to a biased conclusion? And we've seen this in different types of experiments. So if many of you, I'm sure, are familiar with the Adversarial Allegiance study by Dan Murray and colleagues, to quickly go over that, this was a 2013 experiment where clinicians received training on the PCLR and the static 99R, and then were under the impression that they were going to be providing consultation by scoring these risk assessment measures. They weren't actually being hired by firms, but they thought they were. And what they changed is half the people that got this training were told that they were doing these consultations for a defense agency. And the other half were told that they were doing these trainings for the prosecutor's office. Now, they had all just gotten the same training on the same instruments. And what we found was that when you gave that subtle hint that you were doing these consultations for a defense agency, compared to those that had been asked to do this for the prosecution, we saw differences in how people scored a measure looking at the same case information. So what we saw was the predictor in what people's opinions and interpretations were was who had actually hired them, and that we tended to score things in favor of the side that was hiring us. But we see this not only in who is hiring us and what our judgments are, but also by the process of the information that we choose to present. So the thing I want to emphasize here is it's not just our conclusions that can be biased, but it's also the very data that we choose to present in the first place in our reports. There have been surveys of different people using sexual risk assessment tools. And for those of you that have used sexual risk assessment tools like the static 99R and the stable 2007, sometimes you have choices of different recidivism risk tables and norms that you can use. There are 5-year recidivism rates, there were 10-year recidivism rates at this point. And what we found was that if people that were hired by the defense tended to report norms that would show the lowest recidivism rates. So 5-year general correction samples. But when you were hired by the prosecution, even if you came up with the same risk score, you tended to present norms that would reflect higher recidivism rates. 10-year recidivism rates are going to inherently always be higher than 5-year recidivism rates. And the high risk recidivism rates are higher than the routine norms. And what we found was that we've seen that depending on the side, it's not just your judgment, but also the information you choose to show in your reports and to other people in the community reflects some bias that favors the side that hired you. Now, this tendency is what we have called adversarial allegiance, this idea that we're unintentionally favoring the side that is requesting our services. There were a lot of initial reactions to adversarial allegiance, and what I'm going to be going over in the next couple of slides here is some of these explanations, both in terms of what is going on in terms of the courts and the legal system that leads to this bias. But then we're going to also focus on the ideas of what's going on in here among evaluators and those processes that lead to these biases. So in terms of legal factors that contribute to these biases, well, the adversarial system is inherently different than what we tend to do in clinical practice. And the specialty guidelines for forensic psychology seem to even note that there's this kind of tension between what we're asked to be doing and this goal of being objective in a forensic evaluation, that the adversarial system itself can tug away at us, that we have to strive to be unbiased, but that the adversarial process gives us a number of people with a number of different interests, and that we are supposed to treat all these participants and weigh all the evidence equally and objectively. Now, that might be our job as evaluators, but that is not the job of legal parties in a case. Oftentimes, a legal party in a case has a vested interest in presenting the best appearance of a case for their desired outcome. It's not their job necessarily to be objective in a certain case. They want to present the evidence that is credible to support the side that they're presenting. So this can be at tension with what the evaluator is being asked to do. But what the idea here is that perhaps there are attorneys that, because they're trying to present their best side and they worked with prior evaluators, they might know what evaluators are going to tend to interpret things in their favor. And so hiring evaluators that have found in your favor before, or hiring evaluators that have been recommended by working for your side in years past. And basically going into an evaluation, tipping the scales by finding evaluators that seem to demonstrate they're going to find for your side already. There's also the idea that there's internal pressure by the adversarial system that for evaluators themselves, they know that if my finding doesn't favor the side that is hiring me, it's unlikely they're going to hire me for additional services. Now, in some cases, sometimes people are asked to do these in different ways, where you might be hired to do the evaluation, and whether you're actually going to testify is contingent on whether that evaluation actually favors your side. Why is a defense attorney going to ask you to testify if you do an evaluation and your side favors the other side and harms their case? It's not in their interest to hire you to testify. So there's this internal pressure to please the side that has hired you, knowing that it increases the odds that you'll get more referrals or get additional services later on. Not saying this is something that evaluators intentionally think about, but that within the adversarial system, there is an inherent pressure to favor the side that hires you, knowing that it could actually not just impact your present work, but could impact your future work. Now, that's about the legal system at large. The question here, though, is also, regardless of the adversarial system, different types of potential cognitive explanations that could contribute to biased clinical judgment. And there are a number of different theories that we have here, and I'll present a couple of them now. One of them is this concept of cognitive dissonance, where we all know that we are in a helping field but are being asked to be impartial and not favor the side that might have hired us. So there is this internal tension for us, this idea that we're trying to balance helping people and our duty to remain impartial. And we are always motivated internally when we have tension between two different goals or two different needs to resolve that in some way, because otherwise that tension is going to build and build and build on us. So we have to either rationalize or do something that will help reconcile this tension between being objective versus being hired to serve a certain purpose. The simplest way, a lot of times, for us to reduce that tension is to know that the case facts actually support the side that hired us. If we feel like we've been impartial and we have found something that supports the side that hired us, then we can relieve that tension. Now, the idea behind this is that we are then unconsciously motivated to find ways that make us see the case facts supporting our side. And so the idea behind this bias here is that we come into this not deliberately trying to fight for the side that retains us, but that there's something subtle inside us that gives us pressure to give that side the benefit of the doubt. If we believe that the case facts favor the side that hired us, then we can relieve this dissonance and believe we did a fair job, we did an impartial job, and it just happens to support the side that hired us. Now, another issue within the adversarial system is a process called anchoring that can significantly lead to bias. If you've ever tried to resolve a fight between two friends or two siblings, and you think about whose side you heard first, if you ever went in to talk to the other sibling or friend a little bit angry at them because you heard the other side first, you've been anchored. The idea here is that our early information tends to shape the expectations that we're coming in for the rest of the information that we get. So the early information that we get oftentimes makes us no longer neutral to deciding something. If you get hired by a particular side and you're presented with the referral question and why you are being asked to do this, there can be either very overt cues, I'm asking you to find for a specific purpose, or given this person's significant mental health history, we're looking to highlight the significant mental health stressors that this person has experienced. You're being skewed, subtly skewed, to find in one way. That would be perhaps a strong example of anchoring. But even the fact that somebody is coming asking you to help, even if they try to ask for your services as impartial as possible, there can be subtle anchoring that no longer leaves you right in the middle. For one side, you might be getting their blank slate angle. For the second side that you talk to, you can't get the blank slate because you're only going to hear their angle in the context of the other information that you got. So the idea here is that the first information we get, which is oftentimes the referral from the hiring party, that can lead us to bias before we have even started our evaluation. And then we start the evaluation. Anchoring promotes confirmation bias. Confirmation bias is our all natural tendency to look for things that support what we already believe, rather than looking for things that can prove us wrong. And we see this in the world in general. Like we try to look for matches. We look for evidence that we're right. It's way easier for us to do that than to look for evidence that we're wrong. We don't like to think of ourselves as being wrong either, so we spend more time trying to confirm that we're right. So the idea how these two combine together is you get early information that anchors you towards subtly thinking about one side, and then you have a tendency to look for things that support what you're already thinking about. And that confirmation bias impacts both the information that you choose to look at and also how you interpret that information. So we start to not just interpret evidence in a biased way, but perhaps even search for information that will continue to push us toward one side until that ultimately leads to a biased conclusion. So these are all different types of explanations for what might lead to biased judgments in an evaluation at their core. Now, there are also ideas about what might maintain that bias. And so as a little activity here, I want you to think about, we've done different bias studies with different types of groups in forensic science and forensic psychology, and think about who might be more prone to these types of biases. Early career professionals or more advanced mid to late career professionals that have been doing evaluations for a longer period of time. What about mental health evaluators versus forensic pathologists? Who might be more prone to these biases than other people? Within this group, perhaps, who might be more prone to biases, psychologists or psychiatrists? Well, if your responses to these suggested that the group that you think is less biased is the one that you most align with, that would be an example of bias ignorance or the bias blind spot. The idea that we're better at seeing bias in other people and other groups that we don't think are like us than we see in our own group or within ourselves. The idea here is that this doesn't necessarily cause bias, but it maintains it. It prevents us from addressing bias. We're not good at seeing it in ourselves. We're better at seeing it in other people. So we've actually seen cases here where early career professionals might argue that more advanced practitioners are more biased because they're more set in their ways. They might be less involved, less up to date in the latest and greatest research. Whereas more advanced practitioners are more likely to say early career professionals are more biased because they have less training, they have less experience in all of this. And so we tend to, the big predictor on there of your opinion tends to be which group you tend to actually be more of a part of. And we see this within psychologists tend to think that forensic scientists are more biased than they are, and that other psychologists are more biased than they are specifically. But the big issue here is that if we don't see bias in ourselves, we can't address it. And so we don't address what we can't see, which then unintentionally promotes this bias more and more. Now, with all of that in mind, there have been a number of different proposed solutions. And I guess I should call these strategies instead of solutions, because none of these will ever solve bias. Like we said, we can't eliminate bias. The goal, the more realistic goal, is to reduce bias. So I'm going to be presenting 5 different proposed strategies that have been recommended for potentially reducing bias in forensic evaluations. What you'll see here, unfortunately, is that there is very little actual research that has looked at how these are effective specifically in forensic psychological evaluations. But these are all avenues that we could continue to explore down the road. So the first one that I'm going to discuss, it sounds more kinky than it actually is. It's called hot tubbing, if anybody is familiar with this. The other term for hot tubbing is concurrent expert testimony. And what concurrent expert testimony is this idea that was brought up in Australia and Canadian civil courts to address adversarial allegiance by having evaluators from different sides collaborate on a joint report. So they evaluate the same person, then they come together, they discuss the case. They write a report that highlights where they agree, where they disagree, and why. And then on the stand, they testify together and ask each other questions rather than going necessarily through the more traditional individual direct and cross-examination. And so the reason that this has been called the hot tubbing is a pejorative that somebody described with a bunch of experts sitting in the witness box together, saying it looked like a bunch of people talking in a hot tub. Now, the idea here about how this would address bias is that it would switch our commitment and our working relationship and our allegiance from attorneys back to our mental health field. The idea here is that you start to, by collaborating with a colleague in your profession and being on the stand and testifying with someone in your profession, that now you're no longer focused on working with a side, you're working with somebody in your field. and that now your allegiance is less toward legal agencies and more toward psychologists, psychiatrists, whoever is part of your legal profession there. And the other idea behind the testimony is that you are now aware that you are also discussing this forensic case with someone who is very experienced, somebody who knows how to conduct a forensic evaluation, knows all the ins and outs, is as professionally qualified as you are. And the idea here is that that increased pressure and accountability will bring people back to the middle to reduce that bias. So there are a number of things that we can consider just practically in terms of what will be challenges to overcome if we were going to incorporate this idea of having people collaborate together on a report and testify together. Well, one, that means inherently, whenever you're doing a forensic evaluation, we need multiple evaluators. So that is inherently more resources that are required within the legal system. It also perhaps means that this is going to take a longer time to actually get together. You have to coordinate schedules with different evaluators. As it's structured right now, they wouldn't be doing the evaluation together, so they can't see the defendant at the same time. They have to work their schedules around each other. So that complicates things too. Also, it might not be necessarily that if this time lags, they might not actually be seeing the same person. On the one hand, different mental status, different mental states as a defendant talks to different experts, they might actually have different presentations there. But then also the cooperation with the second interviewer. And this is something that we haven't really looked at, is this idea that does talking to one evaluator then influence how you talk to the second evaluator? One, have you practiced? Can you share information better? Is your mood a little bit different? Are you more frustrated by having to repeat things that you said in another interview? The idea here is that even if you ask the same questions, that the second time the person might get different information. Another thing that we haven't looked at is that there might be some power dynamics in the hot tub. We kind of assume when you have two experts that they're on a level playing field. Well, people of different experience levels, people of different genders and races, there might be some subtle different types of power dynamics that go into play when talking together on the stand, and how that can actually impact the collaborative nature of hot tubbing. But the bigger issue is this is one of the few areas that I will talk about that we have actually empirically examined the impact of it on adversarial allegiance. And this is based on some research led by Dr. Jen Perillo that I participated in with Margaret Crivera and Nicoletta Despodova at John Jay, where we had evaluators doing different types of simulated insanity evaluations. So as you can see on this graph, what this demonstrates here is we asked people for their version, their interpretations of insanity at different phases, after they had reviewed case information, after they had written their report, and after they had testified in this study. And we saw for the traditional adversarial process here, you can see clean adversarial allegiance. Those that were hired by the defense were much more likely rated much more strong presence of insanity than those that had been hired by the prosecution. They were looking at the exact same information. The only difference here was who had hired them to do the case. But unfortunately, in our study, we also had people do this process in the hot tub, where we had them collaborate, a defense expert collaborate with a prosecution expert on a joint report and then testify. And you can see here that the adversarial allegiance, the judgments look exactly the same. Regardless of whether we did this under the traditional system or the hot tub, defense experts were more likely to judge the defendant with higher levels of insanity. Prosecution experts were more likely to judge the person as criminally responsible. So overall, the evidence has been that the hot tub doesn't seem to actually address adversarial allegiance. We see the exact same trends in adversarial allegiance that we do in the traditional system. Now, the caveat I want to bring here is that that is the effectiveness of hot tubbing as we currently see it right now. The idea here is that if we collaborate on a joint report, well, the processes that I talked about in terms of anchoring and confirmation bias, those happen early on, day one of the evaluation. And we're not putting in, with hot tubbing, the intervention doesn't happen until you've already done your evaluation. So it might be that it's just too little too late, that you're already biased by the time that you come to make your judgment, and that we need to hit the sources of bias earlier on in the process. Now, maybe we could do that with hot tubbing. There's nothing to say that you can't collaborate on the actual process of the evaluation together. But at least as it's currently envisioned right now of doing it after you've done your evaluation, it seems unlikely that hot tubbing is going to actually address this issue of biased clinical judgment in an adversarial system. Other techniques that have been recommended that would seem to get potentially more at the core of what's causing biased clinical judgment, one would be this process of using counterfactual reasoning. And this would be an individual's practice of trying to identify different ways that you might be wrong, thinking about other ways that people might interpret the same evidence. The idea here is that by taking different perspectives, coming up with an opinion and then saying, why might someone disagree with this? Or why might I be wrong? This forces you to take somebody else's perspective and might remove some of that bias blind spot that we see. We've seen that if you provide reasoning to support a viewpoint that's different than your own, the idea here is that it would draw attention to other things that you haven't been giving strong support for. And that by looking at multiple perspectives, it tempers your confidence in how right you actually are. So it opens the idea of a subtle reminder that I could be wrong here, and there are valid reasons to think about why I'm wrong. So anytime you do an evaluation, you might ask whether you're doing a competency evaluation, and you find that your impression is they're not competent, thinking about, why might someone disagree with me? What would be the evidence that they're looking for here that would support them being competent? And by challenging yourself like that, the idea here is that even if you don't change your mind, you're going to open yourself to a number of different interpretations to reduce overconfidence in your conclusions. Even if it's court ordered, the question would be, how might a defense hired expert disagree with me? How might a state expert disagree with me? And so you're taking in multiple perspectives. Now, some challenges to this is practically, what do we actually do here? So in terms of focusing on what you're going to counter, well, are you just countering your clinical impressions, your conclusion? Are you countering your interpretation of testing data, of your clinical interview? How many things do we try to counter in a forensic evaluation? With a risk assessment measure, are you supposed to counter every single item or just your total score and your impressions of risk? So we haven't really established in forensic practice where we would actually implement counterfactual reasoning. We encourage you to think about alternative solutions, but how often should you be doing it and when should you be doing it in your evaluation? Now, we haven't actually, my understanding to date, we don't have much specific empirical evidence for this in forensic evaluations in terms of reducing adversarial allegiance and those kinds of biases. But we have seen in broader literature in psychology and in other areas of legal psych some support for using this counterfactual perspective, considering alternative ideas to reduce your overconfidence. So we've seen that in eyewitness identifications. We've seen it in judge and jury decisions when thinking about a different conclusion, how confident they are in their own. And we've also seen it clinically in neuropsych diagnosis. It's been shown that before coming up with a neuropsych diagnosis, thinking about what are the other possibilities and why might that be, it's been shown to reduce bias in particularly highly suggestive kinds of diagnoses. So there's some promising ideas here in terms of both the diagnoses that we would have in a forensic evaluation and other bits of different types of judgments that we would do in a forensic evaluation. continuing to bring up this idea that perhaps I am wrong, or perhaps there is another way to interpret all the evidence that I see here. Now, one thing to consider here, and this makes sense with what I've talked about in terms of the idea that it seems like our biased clinical judgment happens early in the evaluation, not at the end. We see that when people try to do counterfactual reasoning, it tends to be more effective if you do it earlier in your evaluation than if you're doing it just at the end. So the take home for this would be that if we were to implement these kinds of strategies in a forensic evaluation, it would be more effective for us to consider alternative explanations in the data that we're looking at. Consider alternative ways to interpret that MMPI. Consider alternative ways to interpret that person's mental health records. Consider alternative ways to interpret their discussion of the factual elements of their case, rather than doing your entire evaluation and then just looking at broadly, why might someone look at all of this differently? We have better prospects of chipping away at that bias if we do this reasoning throughout the process rather than just holding it off until the end. The next strategy I want to talk about is establishing task relevance. So this is a big thing in forensic science right now, is this idea that there is some information that you can get during a forensic evaluation that inherently will be biasing to your judgment. And so when you conduct a forensic evaluation, we should be striving to only focus on the clinical information that is directly relevant to the legal question that we're being asked to answer. So for forensic evaluations, the idea here would be that different forensic questions we get might suggest we're supposed to look at different information. And there might be some stuff that we look at for one type of forensic evaluation that we don't want to look at for another type of forensic evaluation. Now, in order for us to be able to do this, we have to actually establish what is task relevant. So I want you to think about, if you were asked, or if you've done a competence to proceed evaluation, think about the types of information that are absolutely necessary, that you have to have in order to answer that question. What about things that might not necessarily be vital, but are still relevant to help you? And then thinking about different types of information that you could get that not only might be irrelevant and not helpful, but what could actually bias you? Now, one thing to think about here is that the information that could be relevant here could even depend on the jurisdiction that you're doing an evaluation in. So in a competence to proceed evaluation, in some jurisdictions, they require a diagnosable mental health condition. So in other states and jurisdictions, they don't require that. And because of those differences in requirements, mental health records, psychological testing, and other types of issues to arrive at a diagnosis are going to be particularly important to answering a prong if a jurisdiction is asking you, is this due to a mental health condition? But in a state that says competence, you're assessing competency regardless of a diagnosable mental health condition, that stuff might actually be less relevant. Now think about how all of this applies to criminal responsibility and insanity. There might be a lot of overlap here, but I want you to think about if any of your first responses here differ from what you thought about for competence to proceed. There's not a pure overlap. You don't do the same type of evaluation. So there's certain information that's going to be more relevant for one and more relevant for the other. Now, even more specifically, if we think about assessing for sexual risk, well, the question is, what is the purpose of assessing for sexual risk? We might focus differently on historical risk factors versus clinical risk factors, depending on the question we're being asked. So are we trying to offer treatment recommendations? Are we trying to look at if treatment's been effective? Are we looking at SVP commitment eligibility? Are we just describing the person's recidivism risk right now? Depending on what you're being asked to do, that would imply what types of information might be particularly relevant and vital to your evaluation. With all of that in mind, I'd like you to think about, is there some info that could be helpful answering a legal question, but could be not only unhelpful, but maybe biasing for another legal question? The tricky thing here is sometimes we may simply not know what information is relevant until we actually do the evaluation. So as an example, in discussing task relevance, this is something that Dr. Jen Perillo and I have talked a lot about, what kind of information is task relevant or not. And she brought up a piece of information that we would largely consider not only irrelevant, but biasing for a lot of legal questions: victim's ethnicity. So knowing the ethnicity of a victim should generally be irrelevant to whether or not the person in front of you is competent to stand trial. It should generally be irrelevant to clinical risk assessment. What if you're doing a criminal responsibility evaluation and it turns out that part of the arrest or the mental health records involve histories of delusions of persecution toward a particular ethnic group? Well, if you're doing a criminal responsibility evaluation in that context, it might actually be relevant to know what the ethnicity of the victim was, to see if this matches up and is consistent with the persecutory ideas that the person was having at the time. So this is an example here where, depending on the very specific cases, there might be something that's normally biasing that actually might be vital to understanding consistencies in the case. And of course, we can have the flip of this too. There can be stuff that normally would be vital to helping us understand something that could be biasing if it's not relevant to the question we're being asked. Now, in order for us to do this, to focus on elements that are task relevant and ignore the noise that could bias us, we have to establish what is relevant in different forensic evaluations. We've seen preliminarily in forensic science, this is an area where people don't agree as much as we would like. This screams future research in different types of forensic evaluations that we have here. What kind of consensus do we have on different types of forensic questions, and developing a standard of practice that would be, what are the types of questions and types of information that you need for this evaluation? What are the types of information that could be helpful? And what are the kinds of information that, generally speaking, are unhelpful or biasing for each different type of forensic eval that we have? But of course, the problem is sometimes this is going to be case dependent, and we might not know something is relevant until we actually hear it. And once we hear it, we can't unhear it. So it's going to be pretty hard for us to prevent leakage of irrelevant information. But the idea here is, can we get close enough to general standards of the types of information that for each types of practice, you would search for this information, you would ask for this information, and you would not only not look for this type of information, but avoid specific types of information to reduce the different types of biases that you're exposed to. Now that is about order at large, that is about relevance at large, the type of information you would look at. But in a clinical evaluation, sometimes it might not just be about what we look at, but when we look at it. And so for those of you that have done forensic evaluations, if you think about if you got MMPI results that suggested some possible over-reporting, and then you did a clinical interview with the person. Think about if you did the reverse, if you did a clinical interview with a person, and then you got MMPI results that suggested over-reporting. Well, the order might impact how you interpret evidence. You come into the interview seeing testing data that the person might be over-reporting symptoms. That could change how you ask questions, what kind of information you look for, what kind of information you remember from the interview. But if you do it the other way, the interview might factor into how you interpret the MMPI results. So order here might potentially matter as well. And this gets to a particularly complex proposed strategy called linear sequential unmasking. Technically, in this case, linear sequential unmasking expanded. And if we break this down, the first part of it is establishing what is task relevant. But the idea here is a recommended practice that it's not just what you look at, but when you look at it. So the idea here is developing an order for doing a competency evaluation of what data, what information are you going to get first, and then judging that. And then after you've judged that information, looking at historical records. And then after looking at file records, looking at the neuropsych data. And then after looking at the neuropsych data, looking at and conducting other types of testing. This is one example, but the idea here is that we're not just looking at all the evidence in each piece, but we're looking at it in a specific order. And this is something that has been started in different types of forensic sciences, of looking at how might we actually develop a way of doing evaluations in an orderly fashion so that the information is less likely to bias us. And the idea here is that you assess that piece of information, whether it's testing results or psych records or your collateral interview. You judge that piece in isolation, and then you think about it in the context of everything else that you have. So if I was doing a competency evaluation and I got psychological records, and it turned out that the psychological records suggested a history of psychosis, the idea here would be looking at that individually. What might a history of psychosis suggest for competence? And then looking at what might that history of psychosis, in light of everything else I know, suggest in terms of competence. It could be that in isolation, a history of psychosis might increase the odds of somebody being found not competent or somebody being their rationality and understanding of proceedings being compromised. But if the current concerns are about retention of information and have nothing to do with psychosis, then maybe that actually lowers the odds that those psych records are informing on current competence right now. Now, the question is not just what information is relevant here, but what order. And there is a lot of work to be done here in forensic psychology. The complication here is, of course, with different types of forensic evaluations, there are so many different types of data points that we could use and different types of things that could be relevant. Sometimes we look at records, sometimes we interview people, sometimes we do testing, sometimes we look at collateral records and collateral interviews. The idea here would be for each type of forensic evaluation, we would look at, generally speaking, how potentially biasing is that information. And potentially biasing information like victim demographic information, that would be generally pushed to the end of the evaluation. What kinds of information tends to be the most objective, that has the least clinical judgment and least subjectivity to it? The idea here would be the things that are most objective, put that at the front of your evaluation. The things that are most subjective, put them later on. And then also considering how relevant all of the information is. So the idea is, ideally, the first things you would look at in a forensic evaluation would be the stuff that's really relevant to the legal question you're being asked, that is generally consisting of as objective data as possible, that is least likely to be biasing, and then kind of going in an order there. Now, you can imagine we're not going to agree on several of these elements, and so it could take quite a while for us to establish different generally recommended orders for how we should look at different things in different types of forensic evaluations. That being said, there's a lot of potential here for linear sequential unmasking. The idea here is that it reduces the influence of irrelevant information by weeding it out or having it at the end, and that the most influential things in our judgments are the things that are most relevant and least biasing in coming up with our clinical judgment. By also evaluating each piece of information in isolation, rather than just waiting to the end of your evaluation to think about, what do I think about this case? This is going to increase that counterfactual reasoning where you can practice throughout your evaluation. All right, why might this suggest criminal responsibility? But also, why might it suggest the person's not criminally responsible? You can explore and weigh the evidence a lot more incrementally, and therefore chip away at biases more and more frequently. At least that is the theory. Does it work? Well, right now, there's a very strong theoretical basis for this. The idea of taking out the noise, focusing on the most relevant things. There's a lot of justifiable evidence that would suggest that this would reduce bias. But in terms of what evidence do we actually have right now, it's fairly limited in terms of putting it into actual practice. The preliminary work has been mostly in different types of forensic science work, like handwriting analysis, and CSI kind of evidence, but we haven't really done anything in forensic mental health. And so there's a lot of work to be done here, including establishing different order effects. Are there certain ways, do personality testing results bias your interview more than your interview biases testing results? And thinking about how these sequences could actually impact our judgment. But the same challenges that we had before are still in place here, where we can't always know what'll be relevant until we actually see it. And also, if we develop an order, this also, our ability to actually follow that order depends on our access to those records. Sometimes records are not coming in when we actually want them. Sometimes we can't do things in a specific order because we don't have all the information at our table. And so this also requires us to have things on demand when we actually want them. Might be easier said than done. The last strategy I want to talk about here is masked referral that we talk about, or also called blind referral. This idea that if you get hired by a particular side, all of it would be channeled through an intermediary party that wouldn't tell you if you were hired by the defense or the prosecution. Just somebody wants your services. And the idea here is that if you don't know what side hired you, you can't be biased toward that side. At least that's the thought here. It also would compel forensic evaluators to potentially accept a case from any side if you don't know what side is hiring you. Right now, at this point, there is little evidence that it works. We just don't have the data. My collaborators and I are doing ongoing surveys right now to inform its implementation. There are a number of different concerns about whether or not people can actually figure out, unmask and figure out what side's hiring them, just whether it's based on the actual question that you're being asked, or whether there is some subtle biased contextual factors that come in. There are a number of different concerns here about how long this would take, our trust and our faith in this person where we're playing telephone between attorney and clinician, and how accurate that information actually is. And in order to do this, we need buy-in. You're asking not just for an evaluator to sign up for this, you're telling an attorney to release power in terms of who they're selecting and not let them have a direct working relationship with evaluators. So there's a lot of questions up here about how we might actually implement this and how it would actually address biases. So I have a couple of take-home messages here that I want you to leave with here. Ultimately, forensic bias is not just about interpreting our judgments at the end. It's about how we actually go about looking for information and the information that we focus on and remember in the first place. What we have seen in forensic bias is that it doesn't happen at the end. It comes in really early on in the evaluation. So our strategies to reduce forensic bias need to come in early. None of these bias reduction strategies are going to be perfect. They all have their different strengths and weaknesses, but they're not all mutually exclusive either. There's nothing that says you can't do hot tubbing with counterfactual reasoning, with task relevance, for example. What if we start to look at how these strategies work together, just like in public health? You put strategies together to maximize effectiveness. It's the same idea in forensic mental health. None of these things are perfect. So the idea here is, what can we put together to reduce bias as much as possible? And the last thing here is that we have a lot of people that are working on these debiasing strategies and working on trying to understand these. So if you continue to read, go to talks like this, and continue to keep yourself receptive to learning, this will keep us as well prepared as possible to understand that bias so that we can address it in different types of forensic evaluations. Thank you.
Yeah, thank you. A wonderful talk. We have a few questions for those of you who are hanging on. We'll go up past the hour to answer questions. The link is already posted. Alex has posted the link for your CEs, so you can log off if you want. And also, if you have a question, please put it in the QA and we'll address it if we can get to it. We'll get to as many as we possibly can. So let me start. This question is, are you familiar with Scott Lilienfeld's ongoing writings? Well, Scott is gone now, but on bias in clinical judgment, how do you operationalize the application of cognitive heuristics into helping your trainees avoid bias?
Yes, Scott Lilienfeld was a very influential in a lot of people that are doing this work and trying to understand these different types of ways that our mind works during a forensic evaluation. It's influenced people that have talked about forensic evaluation, but all of this comes back to clinical practice too. And so that's something that I have talked about with trainees, even if they're not doing a purely forensic evaluation. If we think about how the order of information we get impacts us, anybody that's done an evaluation with a child might think about, who do you talk to first? The child, the parent, their school, and thinking about hearing the context from the school first might impact what you ask the parents and what you think of the child going in. Talking to the child first might impact what you think about the parents and what you ask about them first. Talking to the parents first is going to impact what you ask the child. So thinking about these things is one step in terms of how can I act, understanding how that might influence the questions I ask, and thinking about, if I didn't have this information, what questions would I be asking? Continuing to basically keep your mind open during an evaluation so you're not prematurely going down one tunnel. And if you're going down a tunnel, it's okay to hit reverse a little bit and zoom out as you're thinking about a case and thinking about the other reasons that people might disagree with you or other things that you might want to explore, to always put the onus on you being right by demonstrating that you could be wrong.
Okay, thank you. Yeah, another question, and congratulating you on the presentation so that people enjoying it. It is a rather detailed question. The example was given that ethnicity is irrelevant to risk assessment, but relevant to criminal responsibility. How about the argument that ethnicity may also be relevant to risk assessment? Sorry, just moved on me. Relevant to risk assessment because it is necessary to choose the most appropriate risk assessment instrument, i.e. the instrument that is valid for the specific population. For risk assessments, would information on the items included in a particular instrument be immediately relevant information?
This is an example of where we might be case dependent, and it might be tricky that you might not know in these examples what instrument will be relevant or less relevant until you find out that information. And if that information is not relevant to your case and doesn't actually impact the instrument that you would choose, now you have ethnicity information that is not actually informing your case, can't help you, can only potentially bias you. So yeah, this is a very tricky area here where we talk about, in some evaluations, it might be easier to set the rules of this is the information you look at, and this is the information that you don't. But there's other types of evaluations where we just may never know if the information is going to be relevant down the road until we actually find it out. So this is something where we really need to be having a lot of conversations within the different types of forensic evaluations, of looking at and agreeing on different types of procedures about when you would look for different types of information and why, and what information you would need first before you would even consider exploring potential noise or biasing information like victim demographics.
Okay, I love this question. So this is, does cross-examination help lessen bias? I would think that knowing that you were going to be cross-examined would encourage an expert to be careful. What are your thoughts about that? So
one of the unfortunate complications here with our discussion of getting alternative perspectives, knowing maybe I'm going to be cross-examined here, is oftentimes we prepare for that cross-examination when? Right at the tail end, when we've done our conclusions, we've done our report, when we have talked with the attorney who's actually going to bring us to testify. At that point, we tend to see that our judgments are pretty solidified at that point. And if anybody's been in a potentially contentious argument where your mind has been pretty set for quite a while, sometimes when you're thinking about those alternative views so late in the game, you're less thinking about how you're wrong and thinking about more, how can I counter that argument? And that's what we tend to see when we try to address bias like cross-examination late in the game, is we tend to focus less on, oh, that cross-examiner has a really good point here. Maybe I'm not right about this. Instead, we're thinking about, how do I react to that? How do I prove to them that they're wrong? Or how do I demonstrate, rather, that I'm right?
People like hot tubbing. Fascinated about the idea of hot tubbing, and I would love to try it. For it to work, it seems that the court would have to agree with it. Do you have any suggestions about how to make that happen?
So I'll also preface this by saying whether or not hot tubbing reduces forensic bias, we have some evidence, the study Jen led, there are some other studies that look at other benefits to hot tubbing beyond forensic bias. So the idea of, is it easier for jurors to actually understand scientific information if the mental health professionals are talking about it rather than relying on direct and cross-examination? Preliminary evidence suggests, yes, it's easier to understand this information because the question, or part of the idea perhaps, is that the questions are more focused. We're highlighting areas of agreement. It's easier to then remember those kinds of things. It also might impact lawyers' selections. But if we're trying to present hot tubbing in court as a way to potentially reduce bias, right now the evidence is not giving us that to suggest that it reduces bias. But the biggest way to come to that would be perhaps to rethink hot tubbing in terms of just collaboration, and think about having experts together collaborate not just on the report, but collaborate ahead of time of how they're going to approach the evaluation, so that they're both thinking about, we're both going to interview the person, then we're going to look at this testing data, and therefore they don't have to test twice or different types of tests, and we'll all look at the same information and then interpret that information together. So implementing it earlier might be All right. Well, it appears that we had some connection issues. Oh, we're back.
Yeah, I'm sorry. Yeah, we lost.
I got dropped too. I just got back in.
Oh yeah. Okay.
Yeah.
Let's see. There's one other question. I think we probably should end after this question. Have there been any studies about allegiance bias in examinations that were ordered by the court rather than being retained by either party?
Yeah, and this has been a very common natural recommendation as well. What about court-ordered evaluations? What we've tended to see is fairly consistently, and we actually in our hot tubbing study, we also had people do it under court order as well, rather than being hired by another side. We tend to see less bias, but pretty consistent bias toward the prosecution and state in a number of different types of evaluations. The idea here is that court evaluations, they're technically not as in the middle objective as we think they are. So they tend to be less extreme bias, but they tend to pretty consistently skew toward prosecution and the state. Part of this could be the natural alignments that by doing something for the court, you're more likely to be in contact and have working relationships with district attorneys than a defense attorney, because the defense attorney is coming completely from the outside of the court. And oftentimes the district attorney is right in there working in hand with the court. So the allegiance is less extreme, but a little bit subtle toward the prosecution.
Okay, well, I think we should stop with that. I'm starting to pick up some more Zoom interference trouble. So
Okay.
I want to thank everyone for participating. Thank you, Anthony. Great addition to our program. We're proud to have you here. And remember, next week we have Lenore Walker, who is always entertaining. We thank you all, and we will now exit.